Mm. So what's what's been the impact on the finance industry, by the way, of this whole story? Have you seen many defaults, problems, renegotiations? How has this been handled in England?
So thanks, Sergey. It's a very unusual situation, really, as we all know, and we've heard stated so many times. And when we first talked about this seminar, in fact, the situation was moving so rapidly day by day. The one thing that has been consistent to our experience, being lawyers working, principally for airlines and leasing companies and their financiers, is that neither party has exercised exercising their legal teeth in kind of really fully formalizing defaults and repossessing aircraft at this stage. Instead, while some default notices we've seen have been served, it's more a question of serving a default notice to protect you legally, and then negotiate to help with the current situation in the existing market, which is unique in that the aircraft are not as marketable or movable as the market is expected to see. So if one lessee isn't paying, there isn't another lessee to go to with the same aircraft. So instead, we've been seeing just countless rent deferral, default cure, kind of forgiveness, forbearance type documentation, and other bits and bobs really associated with the financing packages from lessor, airline, and lessor and financier perspective. So everybody's essentially on the same level play field at the moment. As we predict and suspect strongly that as certain areas of the world start opening up and the aircraft become more portable to other lessees, and the lessee doesn't want to continue leasing the aircraft, then that we'll see more movements, and that could be intra operator, so between or it could be intra-group, where you've got large airline groups, and they'll start to move with lessor consent and financier consent aircraft within groups. And so that will keep lawyers busy, but it will also, essentially be a transaction. But at the moment, really all we're seeing is dealing with the existing aircraft leasing environment. We're not seeing very many new leases, we are seeing some, it's not completely frozen. And of course, we mustn't forget that a lot of the passenger airlines that have been used to carrying passengers, they might not be carrying passengers at the moment, but they're still carrying freight. So, certain aircraft types are still operating just without passengers. They're operating with large amounts of belly freight, and that keeps some of the aircraft, the operating regularly, which some people don't appreciate. And from our US colleagues' perspective, we're still seeing, e-ticket closings, big deals, big new aircraft delivering in a unique environment. And of course, the final thing is that we're now starting to see large-scale Chapter 11 filings in jurisdictions where those types of protective insolvency environments are available. We're not really seeing the filings of airlines in states where insolvency is kind of the end, like for instance in the UK, where we don't have the kind of relative protection, relative comfort of a Chapter 11 type environment. It tends to be terminal. And so at the moment, everything is kind of on a soft standstill there in the UK, and I think in a large other number of jurisdictions. On a legal basis, Jonathan and I were talking, and we thought it might be just worth just mentioning briefly concepts in leases that may be relevant that we haven't really seen used. And one would be the force majeure argument, if present, and another one would be a concept of frustration. But again, just before Jonathan summarizes those, we haven't really seen anybody run arguments to try and get out of leases from an airline perspective. Certainly from the airline perspective, we've seen them really just strongly negotiating with their lessor counterparts to protect their positions and in this unique, equal level playing field environment. Jonathan, did you want to, have I missed anything or said anything terrible? Did you want to
Absolutely not, no. But I think just to touch on the points you did mention with regards to force majeure, I'm sure a lot of people listening to this will have become overnight experts on force majeure when 12 weeks ago we went into lockdown and this situation really started becoming very serious. But we were asked to evaluate by a lot of clients or whether force majeure clauses within agreements would help negotiate, navigate their way through this. Unfortunately, the reality is that a lot of operating leases don't contain force majeure clauses, so there's little room for manoeuvre there. I suppose sort of at a lower level in terms of commercial contracts that they may have entered into, for example, supply contracts, those agreements may well have force majeure clauses in. Whether they cover COVID pandemic that we're seeing now will be determined based on the drafting of that clause. So they would really need to be looked at on a case-by-case basis. The other thing just to quickly touch upon is the English law doctrine of frustration, which provides that a contract can be discharged after its creation if something occurs which renders it impossible, physically or commercially impossible to perform that contract. Again, as Ben mentioned, we haven't seen anyone successfully run frustration as a line of argument to discharge a contract or to terminate a contract. So there may be test cases in the future as the situation hopefully doesn't get worse, but may well continue to get worse. So that again is another live topic which we can perhaps revisit in future webinars.